Greetings. This is an excerpt from two chapters of my memoir, Black Power, Black Lawyer, My Audacious Quest for Justice, centered specifically on the crack cocaine issue and the issue of clemency. And I share this because President Biden just announced commutation of sentences for over 2,000 persons who are unjustly sentenced. And this just gives a little background back in the day to this issue. So, starting with chapter 6, section 3, a frying pan, baking soda, and crack. In 1986, crack cocaine was hyped across the country in headlines as an urban menace that would spawn a generation of crack babies and an epidemic of violence. The public knew very little about crack, other than the belief, later found to be erroneous, that nationally acclaimed University of Maryland basketball star Len Bias died from a crack cocaine overdose. The congressional record was inundated with sensationalized news articles about crack. While there was no rationally sound data or analysis to draw conclusions from, congresspersons, both Democrats and Republicans alike, concluded that crack cocaine warranted especially severe criminal penalties. Congress mandated that a mere 5 grams of crack cocaine, equivalent to the weight of a couple of packs of sugar, would carry the same 5-year sentence as 500 grams of powder cocaine. This 100-to-1 distinction between the two forms of the same drug was, in the words of my colleague and former congressional staffer Eric Sterling, essentially plucked out of a hat. In 1999, I was hired by Mort Halperin and joined the American Civil Liberties Union's Washington office during a time when the federal legislature was drafting and debating the omnibus crime bills that ultimately led to the epidemic of mass incarceration. It was the 103rd Congress that ultimately embraced the largest expansion of the death penalty in modern times, the federal three strikes legislation, the anti-gang provisions, and the prosecution of 13-year-olds as adults. Other than the issue of the death penalty, which was the responsibility of my ACLU colleague, Diane Bastierny, it was my charge at the ACLU to fight to eliminate or, at a minimum, narrow these provisions. In the midst of my advocacy against the omnibus crime bills, the United States Sentencing Commission, an independent agency whose duty it was to advise Congress on sentencing policy, issued a call for public comment on an array of issues. Included was the differential in sentencing between crack and powder cocaine offenses. A colleague from the DC Federal Public Defender Service suggested that I focus the ACLU's comment on the crack cocaine disparity, an issue I was ignorant about at the time. Again, this was the early 1990s when public opinion on the disparity between crack and powder cocaine was undeveloped and research was sparse. Racism in cocaine sentencing had not yet been taken very seriously. This was during a time when Democrats were trying to out-tough the Republicans on criminal justice issues. It was a time when it appeared that the only criminal justice issue the NAACP felt comfortable fighting against was racism in the application of the death penalty. There was no kumbaya across party lines on criminal justice reform, and even I, despite my civil rights and civil liberties background, initially approached the subject with skepticism. Aware of the devastation crack had wreaked on communities of color and also influenced by inundated by exaggerated media images, I assumed because young Black men were so often shown spread eagled on the ground by police or on the way to the morgue from crack cocaine abuse, that they were the primary abusers of and dealers in that substance. I could not have been more wrong. My research, however, disclosed that Blacks were less involved in crack use than whites. Statistics from the National Institute on Drug Abuse documented that the majority of crack users were Caucasian. Oh, these statistics, which were inconsistent with the astronomical increase in arrests, prosecutions, convictions, and imprisonment of young African Americans, intrigued me. The disproportionate increase in Black incarceration directly resulted from strategic decisions made to send more police to communities of color, coupled with the legislation mandating harsher mandatory minimum sentences for crack and powder. My voice on the crack issue was quickly transformed into zealous advocacy. The problem I faced was a dearth of balanced information on the issue at the time. The only material I could scrounge up was a comprehensive feature article in USA Today by reporter Dennis Kachun. The article became my rock and the foundation for my attack. The internet was infantile in those days. There were no law review articles on the issue, no analysis, no reports. So I studied the USA Today piece inside and out. One person highlighted in the article was a mother, Barbara Piggy, whose son, Roderick, a first time offender, was serving a 17-year sentence for a crack conviction. Miss Piggy admonished, quote, "These kids are not the mafia. They are poor, uneducated people trying to survive. You can't just throw away a whole race." The photo in the article of the African American judge from Minnesota, Pamela Alexander, who had recently issued a groundbreaking state court decision, captivated me. Her decision equalized the penalties between crack and powder cocaine in her state. However, the math kept the, However, the math in this issue kept kicking my butt. Despite loving the lure of street life and my sordid history dating quote unquote bad boys, I knew nothing about drugs, grams, kilograms, 101 quantity ratio. Damn, that's not what I thought I would be dealing with as a lawyer. I was embarrassed to overhear Congressman Bobby Scott once remark to his counsel, Bobby Vassar, something to the effect that she keeps saying this wrong. It's not the sentence that's 100 times more severe, but the drug amounts that dictate what the sentence will be. So I sat at Eric Sterling's feet and made him break it down to me until I could parrot the disparity and the math effectively. I submitted the ACLU's public comment and testified before the U.S. Sentencing Commission on the crack and powder cocaine disparity in the spring of 1993. The main feature of the testimony was that the disparity in sentencing laws for possession and distribution of crack and powder cocaine resulted in an enormous and unjust increase in the Black prison population. When I finished, Mrs. Barbara Piggy from the USA Today article approached me to say that she loved my testimony. She expressed that she had flown to DC from California to testify on behalf of her only son, Rod. He had been sentenced to 17 years in prison for an offense involving a kilogram of crack. Barbara was now a representative of a grassroots organization she founded with her son, Families Against Discriminatory Crack Laws. She pleaded that their organization desperately needed a voice in Washington to help expose the crack powder cocaine inequity. Impressed with her passion and seriousness of purpose, I told her that I would do what I could. Within months, armed with statistics, commitment, and a sense of righteousness, I have found my niche at the ACLU, a calling that will follow me for the next 17 years and beyond. Shortly after that hearing in the spring of 1993, I issued a formal call to organizations to mobilize on this issue. The call prompted an immediate response from a coalition of groups coordinated by my colleague, Jean Guerrero. The coalition was already meeting at the ACLU Washington National Office, seeking to establish more rational responses to crime. As a veteran of coalition building, however, I knew our advocacy would lack credibility if the support was limited to the usual Washington suspects. We needed to reach the constituencies most affected by the crack disparity and the organizations that represented them. During those early years, I felt it was crucial to view the disparity not as a crime issue, but as a key civil rights issue. The formulation made it easier to form alliances with organizations not traditionally focused on criminal justice issues. I mobilized a coalition of over 25 civil rights, religious, criminal justice, and grassroots organizations to come together to oppose the disparity. We dedicated our newly formed National Committee Against the Discriminatory Crack Law to what we identified as twin priorities for action: public education and legislative advocacy. Almost 2 months after the initial call, we convened a national symposium on the 100-to-1 ratio entitled Racial Bias in Cocaine Laws on August 26, 1993. Laura Murphy, who had recently come to the helm of the ACLU Washington office, and I got a little picture in there in my book, I'm showing it now with myself and Laura Murphy, who had recently come to the helm of the ACLU Washington Legislative Office, immediately agreed that the ACLU would host the symposium. It was co-sponsored by our newly formed committee, the Congressional Black Caucus Foundation, the Southern Christian Leadership Foundation, and the Criminal Justice Policy Foundation. At the time, I was serving as chair of the Criminal Law and Individual Rights section of the DC Bar. The section also became a proud sponsor. The symposium was convened at the Congressional Rayburn House Office building and fortunately was covered by the still young C-SPAN station. We featured 3 substantive plenaries: the experts speak, the family speak, and a roundtable discussion moderated by American University's law school professor Angela J. Davis, a friend of mine since our Howard undergrad days, whose African name is Amani. The luncheon keynote speaker was Bill Moffitt, then Secretary of the National Association of Criminal Defense Lawyers, and a dynamic brother. We also gave special recognition to Judge Pamela Alexander of Hennepin County, Minnesota, for her recent seminal ruling on the crack disparity. The symposium also featured presentations by Reverend Jesse Jackson and Reverend Joseph Lowry, president of SCLC. That segment was moderated by my political savvy new boss, Laura Murphy, the first African American and female director of the ACLU Legislative Office, who would go on to serve in that capacity for the next 17 years. My organizing was in high gear. This was the first time criminal justice professionals, civil rights advocates, defense attorneys, religious leaders, and family members have been brought together in a national conference to discuss the disparity. The message from the symposium was clear. Increased sentences for crack cocaine were not medically, scientifically, or socially supportable. Furthermore, the long sentences were highly inequitable against African Americans, and I asserted, added up to a national drug policy tinged with racism. It was too provocative at that time to even utter the word racism in professional Washington circles. So I couched the message in nebulous terms such as tinged with racism. Remember, I was working for a majority white organization. But it was not just liberal white groups I had to tiptoe around. During those early days, it was even difficult to convince the NAACP to vocally advocate on the crack disparity issue. I tried hard to convince my colleague Wade Henderson, then chair of the NAACP Washington office, to be an official part of the event on the Hill. Wade knew it was right to be there, and I waved from the podium when I saw him standing at the door. But I surmised he felt too constrained by the NAACP, such that when it came to criminal justice, he had been vocal primarily on issues of racism and the application of the death penalty. This was before the term racial profiling had become widely used. It was years before Michelle Alexander popularized the analogy of the war on drugs as the new Jim Crow, and long before it became fashionable to say that Black Lives Matter. Nonetheless, our determined little committee worked long and hard to lay the foundation for future proponents of racial justice to stand and thrive. We worked with television stations to compose features on the crack powder disparity and provided assistance to journalists and talk show hosts across the country. We produced an educational manual, the Cocaine Equitable Sentencing Briefer, which was chock full of information. Coalition members were frequently called upon to testify as expert witnesses as lower courts began to hold evidentiary hearings on the disparity issue. Coalition members in the American Bar Association were instrumental in getting the organization to adopt a resolution to eliminate unwarranted distinctions that produce racial disparity in sentencing. Of course, this included the 100-to-1 weight ratio between powder and crack cocaine. Our early organizing on the issue in the early 90s helped to plant seeds that elevated public consciousness. Our efforts made the public aware of the plight of thousands of people like Rob Piggy who are languishing in prison under this unequal law. Besides public education, we knew we needed a legislative vehicle to rally around. We held briefings for members of Congress and strategically lobbied Representative Charles Rangel, Democrat of New York, to consider introducing corrective legislation. He was a veteran member of the Congressional Black Caucus, had been former chair of the House Select Committee on Narcotics Abuse and Control, and was known for his tough stance on drugs. He was the perfect sponsor and agreed to spearhead the legislation introducing the Crack Cocaine Equitable Sentencing Act in October 1993. The proposed Crime Prevention and Criminal Justice Reform Act of 1994, affectionately known as the Congressional Black Caucus Alternative Crime Bill, sponsored by Representative Craig Washington, Democrat of Texas, became another legislative vehicle. Representative William Hughes, Democrat of New Jersey, introduced the language of the Rangel bill that would fix the crack powder disparity as an amendment to the 1994 Omnibus Crime Bill being considered by Congress at the time. That's when the drama began to escalate. The markup session in the House Judiciary Committee became heated when some members viewed the attempt to equalize the penalties for crack and powder cocaine with hostility. The focus began to shift away from achieving equity to instead advocating the raising of penalties for powder cocaine. This, they argued, would fix the perceived disparity. To eliminate the risk of his proposal being voted down and replaced by one that would needlessly raise the penalties for powder cocaine, Congressman Hughes withdrew his amendment and instead yielded to a provision directing the U.S. Sentencing Commission to study the issue and submit recommendations to Congress by the end of the year. The outcome of the committee debate was not surprising. This was a midterm election year with politicians clamoring to be amongst the toughest on crime. This political climate signaled an automatic defeat for any rational proposal seeking to lower drug sentences. Congress unanimously passed the amendment not to equalize the sentences, but instead to mandate a cocaine penalty study. It was an easy vote, since the Sentencing Commission was already in the process of reviewing cocaine penalties. The prisons exploded with celebrations. Watching the debate on C-SPAN, many serving crack sentences erroneously believed that they had won a unanimous victory, but alas, it was just a unanimous vote to study the issue. That was a sober and crushing defeat. However, the Sentencing Commission completed its mandated study and on May 1st, 1995, transmitted to Congress its report along with amendments to equalize the penalties for crack and powder cocaine possession and distribution to eliminate the disparity. Again, all hell broke loose. The Sentencing Commission's report provoked a debate on the floor of the House of Representatives that smacked of mean-spirited paternalism. I watched the proceeding on C-SPAN and was appalled to see how differently legislators could view the same set of facts. White members of Congress, by and large, profess to know more than their Black colleagues about an issue directly impacting the Black community. For example, in the floor debate regarding the appropriateness of increased penalties for crack because of the devastation crack had wreaked on Black communities, Representative Bob Barr, Republican of Georgia, rose to the floor and advocated higher penalties for crack. He attempted to validate his viewpoint by recounting his conversations with impoverished Black residents in housing projects, showing their interest in stiff punishments. Quote, "They told me this when I was a U.S. attorney. They tell me now as a representative in the United States Congress, get those people off the streets and put them away from a long period of time." I was pleased as I watched Representative Sheila Jackson Lee, Democrat of Texas, counter. Quote, "It is interesting that Mr. Barr can talk about how he has traveled the highways and byways of inner city Atlanta. But let me say to you that it is all in the asker to the question as to what the responder says. I asked the same question in neighborhoods that I grew up in, and I asked a group of African American ministers, how many of you enjoy your community using drugs? I got no takers. But then I asked the fairness issue. How many of you understand that those who sell crack get 100 times more sentencing than those who sell cocaine? Shock came across their faces because they really understand the needs of their members day after day. They are in the homes of crying mothers who say, he simply wanted to have a job. They are in the homes of crying families who say, where is the treatment facility for those who are addicted? That is what the question becomes. I chuckled as Representative Maxine Waters, Democrat of California, expressed, quote, surprise at much of the rhetoric of these so-called conversations that my friends on the other side of the aisle have been having in minority communities. It's a picture in the book with myself and Congresswoman Maxine Waters. Okay. Where am I? Maxine Waters. Okay. And Black members of Congress were not alone in countering the paternalism. Representative Miller, Democrat of California, effectively stated, quote, I appreciate what the gentleman from Georgia said, but when you go into white houses and white neighborhoods, they want white dealers put away that sell it to white people. But they do not say put them away for a longer period of time than Black people. The suggestion that somehow because Black people believe in law enforcement and do not like people selling drugs in the streets, that means that they are for unequal treatment of people is crazy. The Sentencing Commission reported that they researched and analyzed the issue of cocaine in federal sentencing policy, quote, from every conceivable angle and for many, many, many months, making every effort to consider this critical matter in a thorough and professional manner, end of quote. Nevertheless, Congress summarily rejected the commission's recommendations and rebuffed the wisdom of the very body of experts it had established to advise on sentencing policy. Ironically, the vote occurred on October 18, 1995, just 2 days after the historic Million Man March, where an unprecedented number of Black men converged at the steps of the U.S. Capitol demanding justice and equality. Adding insult to injury, Congress demanded that the Sentencing Commission revise its recommendations so as to maintain sentences for crack cocaine trafficking that exceeded those for powder cocaine trafficking. I was crushed. This was yet another grave defeat. I thought surely that the high-profile Million Man March would have made an impact on this effort, but I was wrong. Now, Bill Clinton was our only hope. Despite the actions of Congress, the president had the power to veto the congressional action and allow the commission's recommendations to become law. Without skipping a beat, we got busy and redoubled our efforts. Coalition members have lobbied, wrote letters, convened high-level strategy conference calls, met with members of Congress. ACLU Director Laura Murphy and I joined awkward meetings with Attorney General Janet Reno and her deputy Eric Holder, which yielded nothing but vague excuses. Others met with President Bill Clinton. Ultimately, none of our appeals were successful, as President Clinton, despite his address during this period, stressing the need to, quote, root out racism, end of quote, from the criminal justice system, signed the congressional legislation gutting the commission's effort to equalize the crack powder cocaine sentencing. We were appalled and castigated the president. The NAACP, which had been an integral member of the coalition for some time, stated their frustration. President Clinton missed a critical opportunity to bridge the nation's racial divide. We are profoundly disappointed that the president failed to follow his eloquent speech on racial healing with the equally enlightening action of a veto, end of quote. In a joint letter to President Clinton, a coalition of civil rights organizations analogizing the situation to the 1993 beating of motorist Rodney King, as well as the crooked detective in the then current O.J. Simpson case, stated, quote, nothing undermines the fairness of the criminal justice system more than these crack laws. Mark Furman and the beaters of Rodney King operate outside the system. But the racism of the crack laws is an official, written, legislatively sanctioned part of the system. Rooting out the Mark Furmans will take time. Rooting out discriminatory crack sentencing is as easy as the stroke of a pen. I was disgusted, disillusioned, and dismayed with the political process and felt betrayed by this Democratic president. Even the savior, the United States Sentencing Commission, apparently acquiesced 2 years later to the unfavorable tough on crime political climate. In April of 1997, the commission modified its principled 1995 call for the complete elimination of the crack powder disparity. Instead, it recommended increasing from 5 grams the amount of crack needed to trigger a 5-year mandatory sentence and lowering from 500 grams the amount of powder needed to generate the same penalty. In a concurring opinion, Commission Vice Chair Michael Gelasic, I forgot how to pronounce his name, Gelasic, Gelacak, okay. He chided the modification, stating that, quote, political compromise is a function better left to the legislature, end of quote. In July of the same year, the administration proposed to reduce the 101 ratio to 10-1. Although this new ratio would be a step forward, it was an inadequate remedy nonetheless. The proposal went nowhere, and the law mandating the 101 quantity ratio between crack and powder cocaine remained unchanged for the next 13 years. I left the ACLU in 1996 to direct the Equal Justice Program at Howard University School of Law, helping to train and inspire the next generation of legal professionals to challenge the unequal administration of justice. After my departure, our crack coalition dispersed, but I never gave up and stridently continued my personal advocacy on this disparity with whoever would listen, students, the media, even taxi drivers. Quote, the evidence has been scientific and persuasive, I continuously argue. Quote, crack cocaine and powder cocaine are pharmacologically identical and have similar effects. They differ only in their manner of ingestion. Both forms of the drug are dangerous, but one is not more dangerous than the other. This is a little picture I put in there. Me had my Afro pup in the days trying to break the chains between the crack disparity. In responding to the constant references to fetal harm, I countered, the term crack baby is now widely understood to be a misnomer, with research indicating that the negative effects of both prenatal crack and powder cocaine exposure are identical and no more severe than the impact of alcohol or tobacco on the fetus. In actuality, all pregnant women should be educated and discouraged against using any dangerous substances, I emphasize. The issue of violence was always just beneath the surface. I stressed, quote, significantly less drug trafficking related violence is associated with crack than was previously assumed, and any cases involving weapons are subject to either enhanced penalties or stiff mandatory minimum sentencing for use of a weapon in connection with a drug trafficking offense. The most persuasive reason for erasing the disparity, I constantly argued, is that only a mere frying pan and baking soda stand between powder and crack. Thus, to apply a stiffer penalty for crack that is sold directly as crack, as opposed to powder, cocaine easily transformed into crack, is irrational. It will be a decade before another serious challenge to the crack powder disparity would manifest. And again, I would be at its helm. Okay, so I'm going to go to that chapter 10 years later. Again, this is part of my memoir, Black Power, Black Lawyer, My Audacious Quest for Justice. This came out in 2020, quite a while ago. So a lot has happened in that time, and I'm trying to find the next chapter. Where are we? Keep going. Keep going. Okay, we're going to start with the chapter 9. That chapter is called Fight the Power. And this particular section, section is called Crack the Disparity. All right, now, let's continue. Again, I'm providing this background because a lot is happening today, a lot is happening in the news today, but a lot of people don't know what led up to all of this. It did not just drop from the sky. There's a sordid history behind all of the momentum that we see today. So, in 2005, on the eve of the 20th anniversary of the 1986 crack law, I revitalized and broadened the crack disparity coalition I created during the previous decade. Once again, our message was to advocate for change collectively. Now, under the aegis of the Justice Roundtable, my goal was to strategically use the 20-year anniversary of the law's passage as a catalyst to encourage renewed public and legislative discussion of the issue. Our new Crack the Disparity Coalition's rallying cry was strong and succinct. Quote, 20 years of discriminatory crack cocaine sentencing is enough. The studies are completed. The research is compelling. The analysis is sound. Now is the time to mend this crack in our system of justice. We plan to publicly launch the campaign at the beginning of January 2006. Unsure of the reception of our campaign on the Hill, we discussed requesting a hearing before the Inter-American Commission on Human Rights to emphasize the crack disparity as the most egregious example of mandatory minimum sentences meted out in U.S. courts. The idea for an international effort came to me quite serendipitously. I gotta learn how to say these words before I actually do my audiobook. Serendipitously. Okay, so y'all know what I'm talking about. Okay. One balmy day in October 2005, during a long leisurely walk from my office, I bumped into Chicago attorney Stan Willis, a colleague from my work with the National Conference of Black Lawyers. Hey, Stan, my brother, what you doing here in D.C.? Nikichi, I'm about to speak at a press conference to provide testimony before the Inter-American Commission on Human Rights on the Burge Police, Chicago Police Station torture issue. Oh, yeah, wow. What's happening with that case? The Burge debacle was a case I was familiar with, having highlighted it as part of my curriculum while teaching my racial disparity in the criminal justice system seminar at Howard Law. It was a case where evidence was uncovered that Chicago police officers seeking to extract confessions of African American suspects in custody routinely tortured them during beatings, electrocution, and strangulation. Well, sis, we've lost faith, Stan lamented. Here we are now in 2005. We've got over 20 years of evidence and absolutely nothing has been done to prosecute. We're moving to a different level now. We've got a replica of the box that we're going to present to the press. He was speaking of the crude wooden box wired to a cattle prod type device that police hooked to the genitals of men they were quote unquote interviewing. So, where are you going again? I asked. The Inter-American Commission on Human Rights on F Street, he responded. I was too embarrassed to tell Stan that I didn't have a clue as to what this commission was. I had frankly never even heard of it before. So here was an international body in my own backyard that I was essentially ignorant of. Although I was not at all familiar with this Inter-American Commission headquartered in Washington, I was intrigued and my mind started racing. I thought if they could get a thematic hearing on police torture, perhaps we could get one on the crack disparity issue. Not too long after my chance encounter with Stan, I noticed that a representative from the Inter-American Commission would be speaking at an upcoming conference of the U.S. Human Rights Network in Atlanta. The network was headed up by my colleague, Ajamu Baraka, who would later become the Green Party's vice presidential candidate after the Obama era. I decided to travel to Atlanta to attend the conference. During lunch, I strategically situated myself in the seat next to Brian Tittemore, the staff attorney for the Inter-American Commission on Human Rights, who was featured at the conference. I peppered him with questions and he graciously provided answers. He explained that the Inter-American Commission on Human Rights was an autonomous organ of the Organization of American States, OAS, whose members are elected by the OAS General Assembly. One of its main functions is to address the complaints or petitions received from individuals, groups of individuals, or organizations that allege human rights violations committed in OAS member countries. Conveniently, the Justice Roundtable's Human Rights Working Group was chaired by Margaret Wong, who happened to be an expert on the workings of the Inter-American Commission, as well as other international human rights instruments. Margaret guided us step by step through the process of filing a petition before the Commission. Because of her brilliant guidance, the Commission accepted the Justice Roundtable's request and convened an historic thematic hearing on March 3rd, 2006. Our goal was to raise international attention to the fact that the crack cocaine disparity was the most egregious example of mandatory minimum sentencing in the U.S. criminal justice system. As chair of the Justice Roundtable, I was thrilled to moderate the discussion featuring an illustrious panel of witnesses. Included was the Honorable Patricia Wald, former Chief Judge of the U.S. Court of Appeals for the District of Columbia Circuit and Judge on the International Criminal Tribunal for the former Yugoslavia. Professor Charles Ogletree, founder of Harvard Law School's Institute on Race and Justice, Attorney Gay McDougall, Executive Director of Global Rights and the first United Nations independent expert on minority issues, and Kimba Smith, who provided her personal story as a directly impacted person. The witnesses testified that mandatory minimum sentences, prison terms predetermined by Congress and automatically levied primarily for drug and gun crimes, violated protected human rights found in the American Declaration on the Rights and Duties of Man and other international instruments. Witnesses cited the wildly disparate sentences between crack and powder cocaine as the most flagrant example of how mandatory minimums have a racially discriminatory impact. The undeniable reality is that harsh sentences for crack cocaine convictions fell disproportionately on African Americans. Perhaps the most poignant testimony of the proceeding during the Commission's 124th period of sessions were the closing words of Judge Wald. She concluded, quote, "Unduly long and punitive sentences are counterproductive, and candidly, many of our mandatory minimums approach the cruel and unusual level as compared to other countries as well as to our own past practices. On a personal note, let me say that the Yugoslavia War Crimes Tribunal, I was saddened to say that the sentences imposed on war crimes perpetrators responsible for the deaths and sufferings of hundreds of innocent civilians often did not come near those imposed in my own country for dealing in a few bags of illegal drugs. These are genuine human rights concerns that I believe merit your interest and attention." This hearing helped to rally renewed public attention to the longstanding problem and re-galvanize the advocacy community. However, this was 2006, and the 108th Congress boasted a majority of Republicans in both the House and the Senate under President George W. Bush. Although what became known as the Second Chance Reentry Bill was making its way through Congress, it was nevertheless a hostile legislative environment for sentencing reform. Our newly reestablished coalition engaged in many brainstorming sessions on the most effective ways to reframe the issue. We determined in this tough on crime environment that it would be more efficacious to stress the themes of punishment and the importance of law enforcement to pursue high-level drug traffickers. This would take undue focus off those involved at low levels. We knew we were in for a protracted struggle. We had laid critical groundwork in previous years on the moral theme of the issue and brought attention to the grave injustice of the gross racial disparities as a result of it. It was critical that the needle now move on the Hill. Our coalition partner, Eric Stuehling, drafted a bill, the Cocaine Kingpin Punishment Act. This proposal couched our message for legislative reform in language that would resonate with conservatives and the law enforcement community. The bill's focus was on large-scale traffickers as opposed to bit players in the drug trade. Its dissemination on the Hill had the desired effect, inspiring Senator Biden to introduce the Drug Sentencing Reform and Cocaine Kingpin Trafficking Act of 2007. Senator Biden's bill came the closest to rational reform of cocaine penalties. However, I will always acknowledge Senator Jeff Sessions for taking the first step in the Senate toward legislative reform on this issue. His bill would narrow the gap between crack and powder cocaine to a 20-to-1 quantity ratio. But it also decreased the amount of powder that would trigger a sentence, although the evidence showed that the penalties for powder cocaine were already tough enough. Our fear all along was that to remedy the issue, the conservatives' call would be to raise the quantity levels for powder cocaine to the crack cocaine level. Our coalition remained united that this was non-negotiable. I also commend Senator Orrin Hatch, Republican of Utah, for introducing legislation to reduce the federal crack cocaine disparity without a shift in the penalty for powder cocaine, which would eliminate the mandatory minimum sentence for simple possession of crack cocaine and bring it in line with simple possession of any other drug. On the House side, Representative Charles Rangel's Crack Cocaine Equitable Sentencing Act had been consistently introduced to each Congress since the days of our advocacy the previous decade. It was now joined by a bill introduced by Representative Sheila Jackson Lee as a companion bill to Senator Biden's crack legislation. The Fairness in Cocaine Sentencing Act of 2008, introduced by Representative Bobby Scott, went further than reform of the crack laws to include elimination of the cocaine mandatory minimum statute as a whole. Yeah. Representative Maxine Waters highlighted the harms of mandatory minimums during the annual Congressional Black Caucus legislative weekend year after year. She audaciously called for the removal of mandatory minimum sentences from federal law with her bill, the Major Drug Trafficking Prosecution Act. Republican Representative Mike Castle, Republican of Delaware, and Ron Paul, Republican of Texas, also vocally endorsed crack cocaine reform. Our Crack the Disparity Coalition firmly supported those bills in the House and Senate that called for the complete elimination of the disparity and, of course, of all mandatory minimum drug sentences. We organized sign-on letters to Congress and congressional briefings. Coalition members drafted reports, testified before the U.S. Sentencing Commission, lobbied Congress, submitted amicus front of the court briefs in support of Supreme Court cases. Again, one of our coalition's most pivotal contributions toward getting the law changed was bringing the human face to Capitol Hill. These were people impacted by these egregious sentences. They included Cedric Parker, the brother of Eugenia Jennings, who testified before the Senate Judiciary Committee in 2009. His sister would become the first person to receive a sentence reduction through clemency from President Obama 2.5 years later. We were eager to bring Willie Mays Aikens to Washington to testify before Congress. His lawyer was Margaret Love, the former pardon attorney under President Bill Clinton and part of our coalition. Aikens was a baseball legend who had recently been released after serving 14 years of a 21-year sentence. He made baseball history when he became the first player to hit 2 home runs twice in the 1980 World Series. Years later, his baseball career sunk as a result of a long-standing, untreated cocaine addiction. Eventually, it led to an extreme mandatory minimum sentence for selling drugs to a female undercover agent who had purposely befriended him for that purpose. Here's a picture of Willie Mays Aikens testifying before Congress. The undercover agent repeatedly begged him to bring her cocaine and to, quote, cook the powder cocaine into crack. As a result, Aikens was arrested and charged pursuant to the harsher crack penalties. Because of the more stringent sentencing penalties for crack, his sentence for selling 2.2 ounces of crack cocaine was treated as though it was an equivalent to selling 15 pounds of powder cocaine. He had just been released from prison in June of 2008 as a result of the Sentencing Commission's adjustment to the crack cocaine sentencing guidelines. Our coalition used his story to underscore the cruelty of mandatory minimum crack cocaine sentencing and the racial disparities between crack and powder cocaine. Okay, this is section 2 of that same chapter. It's called Junk Food Justice. Another significant feature of our Crack the Disparity Coalition's public education campaign was to depict drug quantities with visual analogies. For example, 5 grams of crack cocaine, the equivalent weight of 5 packets of artificial sweetener or a couple of peanuts, yielded a mandatory minimum sentence of 5 years in prison. 50 grams of crack cocaine, comparable to the weight of an ordinary candy bar, mandated a 10-year sentence. 1/3 of all federal cocaine cases involved an average of 52 grams, while only 7% of federal cocaine cases were directed at high-level offenders. To drive this point home, rather than don t-shirts or hats to visualize our message, our coalition engaged in a different type of creative show and tell. We delivered candy bars, sugar packets, and peanuts to each member of the Senate and House Judiciary Committees to remind Congress that absurdly minuscule quantities of crack cocaine yield unnecessarily extreme sentences. We graphically illustrated that despite its rhetoric, Congress was not being tough on crime with these punitive sentences. We emphasized that 2/3 of the federal cocaine cases were being bought against those at the bottom of the distribution chain. Eric Sterling, the former Hill staffer who was now our coalition member, once stated disdainfully, quote, "These are candy bar crack cases, the criminal justice equivalent to junk food, and the federal courts and prisons have become obese with these peanut prosecutions," end of quote. In a meeting with a key conservative congressional staffer, the ACLU's Jesselyn McCurdy explained, quote, "The proper federal role in the nation's anti-drug effort must be focused on kingpins, those international and national level traffickers who smuggle drugs into the country by the hundreds or thousands of pounds. If the Department of Justice is not focused on these highest level cases, as it has not been, then these cases are not being prosecuted," end of quote. I then emphasized to the staffer, quote, "Peanut prosecutions in federal court of candy bar weight crack cases are not tough on crime. If there is to be strong and effective federal drug enforcement, then Congress must, at a minimum, fix the crack powder disparity and mandate to the Justice Department that high-level trafficking cases are to be the new norm for federal court prosecutions." Our argument succeeded in garnering significant conservative and law enforcement support. Conservative allies for reform provided additional cover for Republican members of Congress to do the right thing. They included the National District Attorneys Association, the National Association of Police Organizations, the Federal Law Enforcement Officers Association, the International Union of Police Associations, the Federal Prison Council, AFGE, AFL-CIO, and Grover Norquist's Americans for Tax Reform. We also received help from David Keene's American Conservative Union, Ward Connerly's American Civil Rights Institute, former, quote, drug czar Asa Hutchinson, Pat Nolan from Prison Fellowship, Citizen Link, Focus on the Family, and the National Association of Evangelicals, amongst others. Hearings were held in both the House and the Senate. Police and prosecutors testified for reform. President Obama and Vice President Biden, both on the campaign trail and in the White House, called for change and the complete elimination of the disparity. In addition to congressional bills, attention to reform cocaine sentencing gained momentum from the United States Sentencing Commission and the Department of Justice to the United States Supreme Court. Many, many windows of opportunity opened. We were so close to triumph, but yet still so very far away. It was, if there was ever a moment when change was on the horizon regarding the crack disparity issue, I knew that now was the moment. There had never been as much momentum involving different key players focused on this issue. It was an exciting and exhilarating time to be at the forefront of crack cocaine reform. However, as I cautioned to a newspaper reporter, quote, "It is still critical to remember that these changes represent only incremental progress in the effort to reform the federal crack cocaine law. The Supreme Court's allowance of judicial discretion and the Sentencing Commission's guideline changes will not eliminate or even significantly alleviate the very long mandatory minimum sentences that many people are serving for crack cocaine offenses. The ball is now in Congress's court. Congress must act to eliminate the statutory 100-to-1 disparity. Echoing the coalition's rally cry, I emphatically concluded now is the time to mend this crack in our system of justice. Section 3 of this chapter, Fight the Power, is called, We're Going to Do This Crack Thing, Wade. On July 16, 2009, during Supreme Court nominee Sonia Sotomayor's confirmation hearing before the Senate Judiciary Committee, Senator Jeff Sessions leaned over to Wade Henderson, then president and CEO of the Leadership Conference on Civil Rights. He greeted him before the civil rights leader's testimony and casually remarked, quote, Mr. Henderson, it's good to work with you. Senator Leahy and I have been talking during these hearings. We're going to do that crack cocaine thing that you and I have talked about before, end of quote. After an awkward pause, Wade laughed and graciously responded, Thank you, Senator. I appreciate that. The Senate galley erupted with giggles and snickers. I was only half watching the otherwise monotonous hearing on C-SPAN from my office television monitor when the levity broke. After Sessions' bombshell declaration traversed the internet and YouTube, Wade publicly clarified, quote, please trust me on this. Sessions wasn't talking about doing anything with me and the Senate Judiciary Committee Chairman Leahy that we wouldn't want the world to watch, end of quote. He continued soberly. When Sessions, a conservative Republican from the Deep South, has the courage to talk common sense about crack, then so should other senators and representatives from both parties and every part of this country, end of quote. But it was a chance meeting in the congressional gym's locker room months later, in March of 2010, when a landmark deal was brokered that finally broke through the legislative log jam. Senator Durbin characterized it as a, quote, miracle. He explained that the legislation was at an impasse until he saw Sessions one morning in the gym. Quote, we both showered. We're putting our clothes on. About to leave, he explained, quote, I said, Jeff, give me a number. If we can't do 1-to-1 and I won't go for 100-to-1, what is it? It was 18. I can't tell you why, but it was 18. We agreed, end of quote. Scary sausage making. Ooh, another number arbitrarily plucked out of a hat, yet infinitely better than the original 100-to-1 ratio. Magic number ratios have circulated in the past, promoting ratios of 10-to-1, 20-to-1, 5-to-1, but alas, it was the random 18-to-1 that got traction in the congressional locker room that day. The 18-to-1 bill passed the Senate unanimously that same day. The bipartisan compromise would shave nearly 30 months off of sentences and impact about 3,000 cases a year at a savings of $42 million between 2010 and 2015. It was a compromise that would completely eliminate the disparity for simple possession of crack cocaine and reduce the disparity from 100-to-1 to 18-to-1 for distribution. Was the compromise imperfect? Absolutely. Was there still injustice? Unquestionably. Had the timing been slow? Incredibly. However, when I candidly asked myself, if this was the moment for reform we had been awaiting for so many years, my honest answer could be none other than a resounding yes. I said yes to that question. Because never in the 24-year history of this travesty of injustice had there been agreement on both sides of the aisle. It was July, and as was the case in 1994, we were again on the verge of midterm elections. Rather than waiting to see who would be tougher than thou on crime, it appeared as if the sentiment finally was, let's be smart on crime. As an advocate, was the correct stance the complete elimination of the disparity? My answer, of course, is yes. Should we continue to fight for it? Absolutely. Should we have waited for the perfect scenario to appear? To that, my position was no. This issue had been on the table for nearly 25 years. So many doors had shut in our faces, and so many more people since that time had been arrested and were languishing in prison. When I first started advocacy on this issue in 1993, I was pregnant, walking the halls of Congress and testifying before the United States Sentencing Commission. I did not know her at the time, but Kimber Smith, who would later become the poster child for the movement against mandatory minimum sentences and the crack powder disparity, was likewise pregnant. She, however, was facing a 24-year sentence for crack cocaine disparity. Now, after nearly 20 years of work, my daughter and her son were in their 16th years of life. My position had to be that we had waited long enough for some type of change to occur. As an advocate, I found myself in a bittersweet moment. Bitter because the complete elimination of the disparity was what I knew to be just and right, but was not part of the bill that seemed destined to pass. Sweet, because this was the first time in 24 years that we appeared on the very verge of real change. Bipartisan change was finally about to be implemented on a criminal justice issue that would completely eliminate a mandatory minimum sentence and significantly lower another one. I argued to wavering members of the coalition. I totally agree that the complete elimination of the disparity is the only defensible solution. But this moment must not pass without action that would significantly impact what has been the status quo for nearly a quarter of a century. So while touting the 2010 bill as a first step, our coalition united around the bipartisan compromise, which became known as the Fair Sentencing Act. On August 3rd, 2010, President Obama signed the act into law, reducing the sentencing disparity between powder and crack cocaine from 100 to 1 to 18 to 1. The act represented a crucial step toward federal sentencing that's fair and effective instead of political and punitive. Subsequently, the U.S. Sentencing Commission adjusted its guidelines to conform to the new law and made the adjustment retroactive. 2 years later, the Supreme Court ruled that the law would apply to defendants who were sentenced after the law was enacted, even if their offense occurred beforehand. Let there be no doubt about it. The passage of the Second Chance and Fair Sentencing Acts did not occur in a vacuum. They were largely the result of strategic advocacy by Justice Roundtable working groups, which successfully focused the attention of legislators, the media, and the public on the importance of reentry and sentencing issues. The Fair Sentencing Act signing ceremony was low-key, involving only members of Congress. I was displeased that the advocates, myself included, who worked so very hard on the issue for so many years, were not even invited to the White House to witness the historic signing. There was, however, a pretty nifty reception at the Department of Justice, where Attorney General Holder thanked us for our advocacy and posed for pictures with us. Although we did not succeed in completely eliminating the disparity, very real people are no doubt quite appreciative for the opportunity to have years shaved off their disparately lengthy sentences. I'm sorry, I feel like I'm tearing up. Oh, because someone did come to me years later during one of the National Council for Incarcerated and Formerly Incarcerated Women and Girls convenings. She came in personally, thanked me that it really made a difference. It made a difference in her sentence and brought her home. So anyway, back to the what I'm reading. Okay, despite this historic progress by Congress and advances from the Sentencing Commission, the Department of Justice, and the Supreme Court, I'm sorry, I'm really tearing up. Excuse me. Despite this progress, the fight for fairness, justice, and confidence in the nation's federal drug sentencing policies was not over. Little did I know that I would once again soon become a catalyst in another equally important effort. So I'm about to go into section 4 of chapter 9, Fight the Power, that's called Clemency in Inside Scoop. And this is the background to the commutations that we are seeing today. In fact, today in particular, what is today? January, what's the 17th? I forgot, whatever, during the Martin Luther King holiday, where today President Biden announced that he was commuting 2,000 more sentences of low-level drug offenders. And I'm going to check my thing because he announced that, but when I started reading this, he hadn't put the names of it. He said, today I'm commuting the sentences of nearly 2,500 people convicted of nonviolent drug offenses who are serving disproportionately long sentences compared to the sentences they will receive today under current law and practice. Biden says, with this action, I have now issued more individual pardons and commutations than any in U.S. history. Let me just keep reading from what Biden press release today. Today's clemency action provides relief for individuals who receive lengthy sentences based on discredited distinctions between crack and powder cocaine, as well as outdated sentencing enhancements for drug crimes. As Congress recognized through the Fair Sentencing Act and the First Step Act, it is time that we equalize these sentencing disparities. This action is an important step toward righting historic wrongs. Hello, that's the term I always use. Thank you, Biden. Okay, I didn't get credit for it, but it's all good. Correcting sentencing disparities and providing deserving individuals the opportunity to return to their families and communities after spending far too much time behind bars. I am proud of my record on clemency and will continue to review additional commutations and pardons. Fingers crossed that Michelle West is one of those. It's 9:43 a.m. right now and East Coast time, and I don't see a list yet. I don't see a list. I don't see anything coming across. No, I don't see anything. Okay, so let me read this last chapter. This is real time, y'all, and I'm really tearing up, bringing up all this history. Yeah. Okay, clemency. This is the inside scoop, y'all. Oh, God. Okay. Get yourself together, Nikichi. Okay, I'm reading from my book, Black Power, Black Lawyer, My Audacious Quest for Justice. This is the Black Lawyer part. I'm on page 315 for anybody who has a book and is following along with me. The Fair Sentencing Act was signed into law in 2010. I worked on the issue for 17 long years, overlapping my work with 3 different employers, the ACLU Washington Legislative Office, Howard University School of Law, and the Open Society Policy Center. Although the Fair Sentencing Act reduced the disparity in penalty between crack and powder cocaine offenses, the law was prospective only, not applying to people already sentenced at the time of its passage. Strategically, as progressive advocates, we kept the issue of retroactivity off the table. It would have been legislative suicide to seek to have it attached to the bipartisan bill with the best chance of passage. The lack of retroactivity, however, was fundamentally unfair. Sentences should not be based on a fluke, one somehow lucky to have committed a drug crime after August 3rd, 2010, the effective date of the act, as opposed to a mere day before. If the disparity is wrong today, it was wrong yesterday. It was only fair that the new law should apply retroactively, particularly since it was the egregiousness of the sentences of people already incarcerated that inspired the change in the law. Now that the bill had passed and the storm had blown over, I knew there had to be a solution to this nonsensical conundrum. Always on a quest for justice, I scrambled to come up with a remedy. I have it, I shrieked as I breathlessly blurted my master plan to colleagues. Mass clemency for those who did not benefit from the Fair Sentencing Act. Nikichi, Don't be ridiculous, a close colleague chided. Be realistic. That will never happen, another admonished. Although this proposed remedy was shot down by some coalition members as unrealistic, I knew I was on the right track. I just needed to find the right mechanism and fashion a winning narrative that would provide critical cover in a politically volatile criminal punishment regime. Then someone handed me an article co-written by a law professor who was not familiar to me, Mark Osler. My eyes got big and my brain started racing. This is really it, I confidently proclaimed to myself as I rifled through the pages. This is it, and hallelujah, it's coming from a white former prosecutor turned professor who established the first law school clemency clinic in the country. Perfect. The article talked about nearly 14,000 people convicted of anti-drug offenses whose sentences were commuted through a federal clemency commission established by President Gerald Ford in the wake of the Vietnam War. The article also described President Jimmy Carter's amnesty for draft dodgers that followed. Oh, I was obsessed as I scrutinized this possible precedent from the past. In the Clemency Commission approach, each case was individually reviewed, a remedy that was not seen as a proverbial, quote, get out of jail free card, and a strategy which would alleviate current fears of releasing those who could pose a threat to public safety. It sounded like a plausible model to replicate, and I was excited. I needed a platform to introduce I needed a platform to introduce Professor Osler's Ford Clemency Commission model as a serious pursuit, especially since my, quote, mass clemency brainchild idea failed to pass the lab test, even among some of my progressive peers. As I usually do when stuck and need to generate attention to an issue and garner buy-in from colleagues, I contemplated an educational policy event. This event worked in the early stages of the crack disparity campaign, which I led in 1993 while at the ACLU, when a then nascent C-SPAN televised our day-long symposium and helped thrust the issue into the national consciousness. It was likewise successful as I sought to revive the campaign in 2006 with an historic thematic hearing before the Inter-American Commission on Human Rights. I teamed up with Kanya Bennett, a former Congressional Black Caucus Fellow who had recently joined the staff of the American Constitution Society for Law and Policy. We organized a prestigious breakfast forum in the Congressional Rayburn House Office Building on May 10, 2012, a platform through which I hoped we could normalize a Ford-style clemency commission approach. This catalytic event, reimagining the constitutional pardon power, does the president have a role in making drug sentencing fairer, posed several pivotal questions. Whether the pardon power should be used as a tool for balancing unfair sentencing laws in the criminal justice system. Should clemency in this context become customary? Is there a viable pardon process that can be used? If the pardon power is exercised regularly, how do we ensure fair and non-discriminatory procedures? Are governors setting an example at the state level for how pardon powers should be used? I strategically placed Professor Mark Osler, whom I hope to be the savior of the clemency expansion concept, as part of a slate of experts convened to consider these questions. To my relief, the briefing was a slam dunk. In addition to Osler, panelists and keynoters included former Obama White House counsel Greg Craig, who called for reform of the clemency process during his tenure, former Maryland Governor Robert Ehrlich, who used his clemency power as a customary basis in his state, and former Clinton pardon attorney Margaret Love, who authored an authoritative text on the reinvigoration of this executive power. Also joining the briefing was ProPublica senior reporter Daphne Lindsay, who had recently uncovered evidence of dysfunction and discrimination at the Office of the Pardon Attorney. And to round out the briefing, I included American University constitutional scholar, Professor Jeffrey Crouch, my ride or die partner in crime, Jessalyn McCurdy from the ACLU, and Cedric Parker, the brother of Eugenia Jennings, his sister being the only person at that time who had been granted clemency by President Obama. Although Kanya and I had no idea what might happen, we stepped out, as my colleague Dr. Von Daniels of the Institute of the Black World 21st Century says, we stepped out on guts and faith. I pulled out all stops to popularize the idea of using a Ford-style clemency board as a remedy for relief for those not impacted by the new crack law. Mark Osler was indeed my savior. Being a Washington insider with critical contacts, I also had something he was missing and needed. Mark and I made a great and diverse team. Several times earlier, I had spoken with Tino Cuellar, Special Assistant to the President for Justice and Regulatory Policy, about criminal justice policy reform. He left the White House before I had the opportunity to discuss this emerging prospect for reform. Tino was replaced by Tanya Robinson, an African-American attorney who reminded me that we originally met when she was a new staffer with Senator Biden years earlier, while I was working on the crack issue during my time at the ACLU. I introduced Mark to Tanya, and the three of us had several meetings, or in White House parlance, quote unquote, listening sessions. Tanya was a great listener, very polite, and seemingly interested in our appeals, but characteristic of White House staff, totally discreet and noncommittal. It was frustrating. We essentially handed the administration a model toolkit for execution of a clemency process, complete with a sample executive order and a presidential proclamation Mark drafted. However, we could get no hint, signal, or other intelligence from our courteous but cautious White House official. We did, however, glean that concern about the cost of implementing such a board may be a stickler. President Ford was not confronted with that concern. He had discretionary funds which obviated the need for congressional approval. President Obama, on the other hand, already battling Republicans in Congress, would likely have an insurmountable barrier getting a commission approved that would cut drug sentences short, no matter how meritorious the case. By now, coalition partners of the Justice Roundtable were firmly on board with a Ford-style clemency review commission concept. It made sense. And the coalition initiated a broad-based sign-on letter demonstrating wide support for the concept. I organized several meetings at the White House for Justice Roundtable working group leaders to meet Tanya and formally present our Clemency Review Board sign-on letter and educate her to the working group priorities. The meetings were good, but it was unclear whether we were making any headway. Our White House listening sessions nevertheless continued. With a foot now in Washington, Mark initiated other high-level meetings, even, I understand, surreptitiously leaving a copy of the voluminous Ford Clemency Board report manual in the office of Vice President Biden. Here's a picture of Mark Osler. You can't see it too well, but with a copy of that voluminous Ford report, executive clemency report, thingamajigam. Okay. Where am I? Okay. Tanya left the White House in 2014, replaced by Roy Austin, Deputy Assistant to the President for Urban Affairs, Justice, and Opportunity, who I interacted with on a variety of issues until the end of the Obama administration. In the realm of clemency, it seemed as if the entreaties of Mark and myself were falling on deaf ears, and precious time was ticking as people continued to languish unjustly in prison under an outdated and disgraced law. And then it happened, a break. Woo! In December 2013, President Obama commuted the sentences of 8 people serving harsh prison terms on crack cocaine convictions. This was momentous. However, the 8 commutations represented only the tip of the iceberg of cases left behind when the Fair Sentencing Act became law. The Justice Roundtable Coalition applauded President Obama for using his clemency power to achieve the important public policy goal of bringing attention to those still in prison from a policy nearly universally discredited as unfair, inconsistent, and fiscally unsound. However, because of the sheer volume of the cases and the impracticality of the current manner of processing, we again strongly urge the president to establish a review board to vet the old crack cases languishing in the beleaguered office of the pardon attorney so it could make appropriate recommendations for clemency. Clarence Aaron, whose name the Justice Roundtable had elevated for years and was the star of Daphne Lindsay's ProPublica expose, was one of the 8 people serving lengthy mandatory minimum punishments for drug offenses who had their sentence commutated by President Obama that December. Norman Brown, who would later dine with President Obama, was another. Now, instead of dying in prison, they and 6 others had a chance for a productive life. In an interview, I stressed a broader approach. Quote, the Obama administration has recognized that we over-incarcerate, over-punish, and essentially throw away the key, I reflected. I am indeed ecstatic with these 8 commutations, but a more direct path to correct the flaws of drug law sentencing is through a systematic exercise of the clemency power similar to the drug and anti-war commutations of the past century. I concluded by asserting President Obama should follow the path established by Presidents Kennedy, Ford, Carter, and Clinton, who, with the stroke of their pens, sought to right historical wrongs through widespread clemency. 2 months later, in February 2014, President Obama's Deputy Attorney General, James Cole, announced a groundbreaking clemency initiative to adjust certain outdated sentences of deserving candidates using the president's power to commute or shorten drug sentences. For our criminal justice system to be effective, it needs to not only be fair, but it also must be perceived as being fair, Cole stated. Quote, older, stringent punishments that are out of line with sentences imposed under today's laws erode people's confidence in our criminal justice system. And I am confident that this initiative will go far to promote the most fundamental of American ideals, equal justice under law. The cornerstone of the initiative were candidates sentenced under archaic laws that had since been overturned and were no longer seen as appropriate. This included people who did not benefit from the reduction in law around crack cocaine because it was not retroactive, as well as those unable to benefit from other major changes in sentencing policy over the past several decades. This was a major and welcomed expansion from the approach limited to crack cocaine cases I was advocating in support of, and an inspiring reminder to me to never limit potential remedies. Although we handed Tanya the fruit of our advocacy on this issue on a silver platter, briefed Roy, met with other officials, and educated the media, Professor Osler and I never had a clue as to whether the concept of a clemency commission was ever taken seriously. I cannot prove that this new clemency initiative was the administration's response to our advocacy, but in my mind, how could it not be otherwise? Okay, I'm gonna take a brief break for a moment. Y'all just hold on for 1 second, and we will be back to this critical narrative. So y'all take a break. And now I'm going to be going to another area to continue this critical discussion. Oh Lord. I'm not sure where I'm going. Better go up here. Okay, going in my junky office. Lord mercy. Okay, gonna be continuing just a second. This isn't the official audiobook, y'all. I haven't gotten to that yet. Let's turn on my big light. But this is going to spur me to go on and do that audiobook. Okay, so where was I? Drink some water. Y'all get some water too. Still waiting to see if President Biden has, I think he's come up with the names. Not sure if he are the names out. I'm checking to see if Michelle West is on this list. I don't know. Are the names out? Question mark. Okay, I haven't seen anything. Oh boy. 1 second, y'all. Y'all take a break. Woo! So I should have, something would have come across somewhere if names had come out. Okay. Okay, so I'm going to go and continue. So again, anyone interested in the background to Biden's decision today, commuting all of these sentences, that's what I'm providing right now for my memoir, Black Power, Black Lawyer, My Audacious Quest for Justice. This stuff dates back a couple of decades. Okay, so now we're at the Obama administration. Here I am. Okay, continuing. Criteria for the cases, however, were limited to consideration of candidates who had served at least 10 years, were low level and nonviolent, and had a clean prison record with no significant gang related ties. Rather than implementing a Ford-style review board or commission, the Department of Justice appealed to the legal community to assist in the identification and vetting of petitions and identified 5 organizations: the National Association of Criminal Defense Lawyers, the American Bar Association, American Civil Liberties Union, Federal Public Defenders, and Families Against Mandatory Minimums to coordinate the screening of candidates and the training of those interested in preparing commutation petitions. I was thrilled when an African American senior attorney from Georgia, Cynthia Roseberry, was hired as executive director of the 5-member organization coalition named Clemency Project 2014. Over 35,000 prisoners ultimately answered the call for pro bono representation for relief from their unjust sentences. Despite its limitations, with his historic clemency initiative, President Obama did exactly what our breakfast briefing 2 years earlier advocated. He reimagined the policy discussion around widespread incarceration and the proper role the office of the president could play to alleviate harsh punishments via clemency, to bring balance to a justice system that for decades had meted out extraordinarily lengthy sentences that often had not fit the crime. The executive focus he initiated on classes of people adversely impacted by unduly harsh sentencing policies injected urgency into the national discourse over mass incarceration. With Clemency Project 2014 in full swing, I felt it would bring value to the movement if the human faces of clemency were highlighted and lifted up. In 2015, I reached out to my White House colleagues, Roy Austin and Stephanie Young, to gauge their interest in co-sponsoring an event to honor President Obama's clemency initiative. I suggested it be titled Redemption, Reconciliation, and Reentry, honoring President Obama's clemency initiative. I recommended March 31st, 2016, because that date would coincide with a national convening Mark Osler was hosting in Washington, D.C., of organizations and law school clinics involved in clemency efforts. I told them the purpose of the event would be to honor the White House's clemency initiative and the people who have been released. I wanted to uplift their stories as well as the stories of those assisting them to reintegrate into society, such as family members, housing providers, employers, faith advisors, mentors, etc. I pledged that the Open Society Foundations would fly in targeted commutation recipients to share their journey since release. I told them I reserved a room at the National Press Club building for such an event, but would love to partner with the White House and hold the event in the South Court Auditorium on the grounds of the White House, if possible. I recommended that the commutation recipients we bring to Washington have the opportunity to share their narratives, along with remarks by President Obama, Valerie Jarrett, White House counsel Neil Eggleston, pardon attorney Deborah Leff, and Attorney General Loretta Lynch, among others. I stressed that it would be good if there were an opportunity for commutation recipients to be flanked by President Obama as he executes a mock or real signing of the letters awardees personally received from him. Finally, I stressed that the Justice Roundtable Coalition would do the necessary footwork to make the event a success for the administration. The White House, being forever secretive and non-communicative, would not give me a definitive answer, causing me concern. I knew we had to identify candidates, book airfare, block hotel rooms, and everything else associated with coordinating a large event. I was frustrated. My husband and I were blessed. My then husband. Okay. My husband and I were blessed to attend the Obama's annual Christmas party at the White House. Before leaving, I spotted Ashley Allison, Deputy Director in the White House's Office of Public Engagement. After catching her attention and engaging in small talk, I repeated my spiel on the importance of a high-level clemency gathering at the White House and asked about the status of my proposal. Ashley, with true White House guardedness, merely stated that it was being considered, but I was encouraged by her huge smile and the twinkle in her eye. It was hard to determine who would be the White House person to make such a colossal undertaking happen until Elias Alcantara came to my attention. Elias was Senior Associate Director in the Office of Intergovernmental Affairs. He and I began to exchange emails. A firm date was established and the pivotal event was shaping up. Although the final program differed somewhat from my original conceptualization, it was a dream come true. The White House titled the March 31st, 2016 event, quote, Life After Clemency. And my assistant, Jasmine Mickens, and I proceeded with the mammoth task of coordinating the travel and logistics for invited attendees, as well as interfacing with the Federal Bureau of Prisons to ensure permission for those on parole to travel. My only strong request was that the White House coordinate with the Secret Service to either abandon its policy of requiring red badges for those deemed a security risk, i.e., anyone, which included anyone with a criminal conviction, or to adopt a policy for that day requiring everyone to don the red badge, thereby eliminating any distinction between the formerly incarcerated and never incarcerated. The request was granted. I worked closely with Elias to ensure the success of the White House Clemency Summit. At some point, it was clear to me that something secretive was going to happen during this process, but I had no clue what it was. Unbeknownst to me, I helped facilitate a secret luncheon for clemency recipients. President Obama and his senior advisor, Valerie Jarrett, were planning at DC's Bus Boys and Poets, an upscale restaurant owned by entrepreneur Andy Shalal, who had a positive history of hiring formerly incarcerated people. Because of all the secrecy, I presumed that there was going to be a meeting with President Obama, but I thought it was going to be in the Oval Office. Never in my wildest dreams would I have imagined the creative way in which this historic meeting would occur. Although disappointed because there was no indication that I was to be included in whatever was being planned, I did my best to satisfy the White House's desires. Elias asked which clemency recipients the Open Society Foundations will be flying in for the Life After Clemency event. I gave him some of the names we were exploring. Elias sounded happy when I named Ramona Brandt. His reaction was the same with my recommendations of Norman Brown and Kimber Smith. He asked if Angie Jenkins was on the list. I gulped. I think she is. Angie was one of the names Clinton-era commutation recipient Amy Povar had previously given me as a possible person to bring to Washington. But Angie lived in Oregon, and getting her to DC sounded like it might be a logistical nightmare. When Elias mentioned her name, I knew I had to make the trip happen. He also asked about George W. Bush-era commutee Frederick Emmert, to which I said, I could make that happen too. The same with Clinton commutee Serena Nunn. The four of them joined Norman Brown and Michael Short, who were local, and Kimber Smith, who was already confirmed to come to town. Elias's instructions were definitive. Make sure they are in DC by the morning of March 30th. Make sure they know that White House security, make sure they know what White House security entrance to go at. Make sure they are on time. I went to the airport to pick up Angie Jenkins the evening before. I will never forget the amazed look on her face when she approached my makeshift sign with her name on it. We hugged. She was so very thrilled and excited. After being incarcerated for nearly 18 years, this was her very first flight, and it was indeed a logistical nightmare to get her from the West Coast to a layover halfway across the country and then on to Washington, D.C. But she weathered the storm admirably. Upon entering her plush hotel room, Angie just kept twirling around the room, repeating over and over, "Oh, I just feel like Cinderella. I feel just like Cinderella." My husband was the designated driver to pick up Ramona Brandt and Serena Nunn, the last commutees to arrive, both arriving late the following morning. He had instructions to drop the women off at the White House security guard's entrance on 17th Street. Ramona's flight, however, was delayed. Little did I know that the five commutation recipients were already in the White House Roosevelt room. President Obama had just surprised them, bursting open the door with the green, "How's everyone doing?" And then, after the shock and amazement wore off, he continued, "I have a little spare time, so let's go out to eat." Elias called me to ask for the driver's phone number, which I gave. Rather than take them to the guard's entrance, the driver was instructed to transport Ramona and Serena to the Busboys and Poets restaurant on 14th Street Northwest. My husband, then husband, well, okay, the driver later told me, "Busboys and Poets? I thought that was strange." But of course, I didn't question the White House. Now, it would have been great if my hubby had called to give me the heads up that there was a change in the drop off logistics instructions. I might have just happened to saunter on over to 14th and B Street for lunch at the opportune time, but alas, he did not. The seven who were selected by the president to join him for a private discussion at Busboys and Poets had a unique and once in a lifetime opportunity to engage in dialogue with the country's chief executive. Norman Brown walked out of prison in 2015 after being granted clemency by President Obama. Norman was not a super predator. He is a grateful, enthusiastic, hardworking man who spent over 2 decades of his life behind bars. He is a man whose mother, father, and grandmother all passed during his incarceration. He is a man who left behind an infant daughter when he was locked up. He is a man dedicated to reaching back and helping those still in prison, equally deserving of clemency and equally deserving of the benefit of a change in laws that allow people to be warehoused without a second look. President Obama queried the seven and asked whether they felt they were the exception, whether they were that different, and they all answered emphatically, "No. We left behind people who, like us, are as deserving or better," Norman said. The diners emphasized that they were far from unique, but representative of thousands of others who likewise deserve a second chance. Hold on one second. I got to check my text again. I think something might have come in from the president. Let me see. No, that's just something else. I'm still waiting on these names. I'm waiting on these names to see if Michelle West is on the list. Oh, I hope she is. Okay. Back to this. This is real time I'm doing now, y'all, but I'm relating back to the past. Uh, mm, yeah. Okay. All right. Continuing. This is history, y'all. And I'm doing this because it's history and because in this time of short sound bites, we don't always know what went behind what's going on now today. And that's what I'm trying to share with you. So just bear with me just a little longer. Whew. Valerie Jarrett, who was present in both the Roosevelt Room and at the lunch meeting at Busboys and Poets, described the experience at the Life After Clemency White House event the following day. She said, quote, "They told their stories with grace and honesty. There was not a dry eye in the room," end of quote. That same afternoon came the announcement of an additional 61 commutations by President Obama. I was thrilled, yet bittersweet, as a name I was constantly seeking was not on the list. That name and that story is in another chapter. I'm not doing that at this time. Okay. Because the March 31st White House convening was invitation only and closed to the press, the Justice Roundtable hosted a wraparound series of events to allow for fuller participation and permit the media an opportunity to interview and interact with the formerly incarcerated people who have been granted clemency, as well as other formerly incarcerated people and family members of those behind bars. We hosted a fabulous welcome reception the evening of March 30th. Formerly incarcerated people and family members of those hoping to be released made critical connections with the Washington advocacy community and White House staff. Andrea James wowed a packed audience in the South Court Auditorium earlier that day in an armchair discussion with Valerie Jarrett as part of a Women in the Criminal Justice System convening. Here's a picture of me and Andrea with her book that had come out called Prison Buddy, Upper Bunkies Unite, Upper Bunkies, the bunk or the prison thing. I had met Andrea in 2013 at a forum sponsored by the Institute of the Black World 21st Century that was part of a Drug Policy Alliance conference in Colorado. I was already familiar with her book, Upper Bunkies Unite, but when she burst into the IBW session with children, fundraising dish towels and pot holders in tow, I knew that this sister was about business. We established a warm relationship, and she brought her sisterhood crew to the Washington convenings held March 30th to 31st, 2016. She was in the process of building what would become a powerful organization, National Council for Incarcerated and Formerly Incarcerated Women and Girls. The Justice Roundtable hosted a Conversations on Justice event the morning of the White House's Life After Clemency convening. This affair featured formerly incarcerated Shaka Senghor, author of the newly released memoir, Righting My Wrongs, Van Jones, CNN political commentator and founder of the organization, hashtag Cut 50, introduced Shaka, who had recently appeared on Oprah Winfrey's Super Soul Sunday show. The Roundtable's finale was a special invitation-only banquet dinner directly after the White House convening, hosted by Google, and compliments of my longtime colleague, Malika Saada Saar. This was her first criminal justice gala event at Google after recently being hired to lead the tech company's civil and human rights policy agenda. The genius of these Justice Roundtable hosted wraparound events is that they brought together people from different locales across the country into one space. These events were often the catalyst for critical relationship building that seeded and sprouted initiatives that bear fruit today. The presidential commutation recipients we convened in Washington to participate in the 2 days of historic clemency activity, represented several presidential administrations. The sentences of Clarence Aaron, Ramona Brandt, Norman Brown, Eugene Hayward, Jason Hernandez, Angie Jenkins, Sharonda Jones, Vicky McCall, Alta Mills, Rudolph Norris, Shauna Barry Scott, and Reynolds Wintersmith were all commuted by President Obama. The sentences of Philip Emmer and John Forte were commuted by President George W. Bush, and the prison terms of Dorothy Gaines, Serena Nunn, Amy Povar, Michael Short, and Kimber Smith were commuted by President Clinton. Roach Brown's blessing came from President Gerald Ford. These were people who came to this convening. Family members of commutation applicants were there awaiting decision by the president. Those who joined our activities included Beth Curtis. Hold on one second. Phone is ringing. Family members of commutation recipients, family members of commutation applicants were there awaiting decision by the president. Those who joined our activities included Beth Curtis, whose brother was serving a life sentence for pot, Tretessa Johnson, and Katina Scales, daughters of Alice Marie Johnson, who was serving a life without parole sentence for drug conspiracy. Jasmine Mickens, whose brother was in prison. Vanessa Rosa, whose sister received clemency that weekend. Anthony, Ebony, and Miko Underwood, whose father was serving life without parole for drug conspiracy. Rudy Valdez, whose sister was serving life without parole and later produced a film about time on the outside, the sentence. And Miquel West, who sought to generate attention on behalf of her imprisoned mom, Michelle West. Okay, break again, just checking to see with that Michelle West, see if President Biden has listed the names of the people. Look, no one sent anything to me yet, so I guess it hasn't come out yet. Boy, names have not come out yet. All right, continuing. Okay, on that beautiful March afternoon, the group strolled leisurely down the street from the Open Society Foundation's office on Pennsylvania Avenue Northwest to the White House security gate. You could feel the exhilaration and anticipation in the air. People gathered who never thought they would again experience life on the outside of prison and who were now walking alongside advocates whose life's work had been about ensuring this very freedom. Adult children of incarcerated parents patiently waited in the White House security line with the anxious hope that someone would hear their pleas for mercy for their loved ones. Film crews followed clusters of people documenting their commentaries and movements. Little did anyone know that Tristessa and Katia's mother, Alice Marie Johnson, serving life without parole sentence, would be coming home within 2 years with the result of intervention by celebrity Kim Kardashian, who took her plea for clemency to President Trump. It was indeed an historic convening inside the South Court Auditorium on the grounds of the White House, which provided a collaborative environment for not only commutation recipients, but also for so many others. Formerly incarcerated people, senior administration officials, academicians, private sector stakeholders, and the advocacy community all came together to discuss ways to improve paths to reentry for the formerly incarcerated and help improve their lives upon returning to their communities. Elias Alcantara was the master of ceremonies for an afternoon chock full of featured speakers that included White House counsel Neil Eggleston, Deputy Attorney General Sally Yates, Assistant Attorney General Carol Mason, Clemency Project 2014 Director Cynthia Roseberry, Professor Mark Osler, and Professor Mike Romano. Perhaps the highlight of the day was the panel moderated by Deputy Assistant to the President Roy Austin, which featured commutation recipients Ramona Brandt, Norman Brown, Rudolph Norris, and Shauna Berry Scott. They shared moving stories of the difficulties they faced securing housing and employment, reestablishing relationships with loved ones, often after decades of separation, and having to learn to maneuver technological advances such as mobile phones, the internet, ATMs, and self flushing toilets. Valerie Jarrett's moving remarks during the event stressed the importance of personal stories, where she reminded us that's how change happens in this country. The life after clemency convening began with Elias inviting all those who had received the commutation of sentence to stand and be acknowledged. The room erupted in thunderous applause, and the event ended with an outstanding performance by Fugees producer and rapper John Forte, who himself received clemency in 2008 from President George Bush, W. Bush. I was once asked by someone, if I were to do it all over again, what would I have done differently? My response, I would have adhered to my original initial vision and had President Obama come out on stage, seated behind a desk with formerly incarcerated people that he granted commutation to, stand surrounding him as he began the signing of thousands of clemency petitions. And I would have opened the White House Life After Clemency convening up to the media so that its significance would be forever enshrined in the nation's consciousness. So I'm going to just now share the last part of this from my memoir, Black Power, Black Lawyer. This is chapter 9 called Fight the Power, section 6, Redemption, Mercy, and a Slam Dunk Radiothon. Okay. Rozier Roach Brown, an icon in the Washington, D.C. community, is the epitome of redemption and mercy. He is someone who made a mistake, was given a second chance, and when he made a mistake again, he was given a third chance. Because of the chances he was given, the community has been richer as a result. He heartily greets everyone with the phrase, Merry Christmas, regardless of the season or time of the year. As he explains, quote, it reminds me of all the good and bad things that have ever happened in my life around the holidays, end of quote. It was Christmas time in 1975 when President Ford commuted his 20-year to life sentence to 30 years, making him immediately eligible for parole. Roach, who grew up poor in the alleys of DC with no plumbing or electricity, once explained to me that he received his nickname as a young boy because he had a reputation of being, quote, so stubborn and hard to get rid of, end quote. And it was this tenacity that ultimately resulted in the commutation of his life sentence. In prison, as part of his transformation from drug addict to community activist, Roach founded the Inner Voices, a theater troupe which performed plays he had written about the horror and humor of prison life. His work with the Inner Voices garnered so much goodwill and trust that the men were granted furloughs to leave Lorton Reformatory over 1,500 times to perform throughout the country. The company even came to the attention of the U.S. Senator from Massachusetts, Ed Brooke, a Black Republican who befriended the prison playwright and assisted him in getting clemency from President Ford. Roach Brown, however, was no angel. He'd been convicted of a murder and a robbery gone bad, sold drugs to an undercover agent, and most shamefully embezzled $45,000 that was to go to a children's charity. Since the commutation of his sentence in 1975, and despite these other crimes which landed him back in prison before his final release, he made invaluable contributions to the community during his releases. He has testified before Congress, directed a performance by the Inner Voices for members of the Senate, served as a special mayoral assistant, won acclaim at the New York, Sundance, and Cannes film festivals, produced a television news show and radio show that he still hosts today, designed a drug prevention program for the Embassy of Ghana, registered formerly incarcerated people to vote, and helped to feed thousands of needy DC residents throughout the years on Christmas Day. Although they knew about Roach Brown and the fact that he had been granted clemency by President Ford, I understood, yet disagreed with why President Obama likely declined to include him as part of his historic Busboys and Poets luncheon. Roach was the opposite of squeaky clean. He had been a heroin addict and later a crack addict. But more egregiously, he had been convicted of a violent crime, murder, and he had also engaged in fraud. But if we are to really significantly reduce the prison population and end mass incarceration, we all must find the courage to move beyond the mantra of the first-time nonviolent drug offender, including Roach. In the lineup of presidential clemency recipients would not only have included another presidency, it would have also demonstrated that America is not afraid of what traditionally has been deemed, quote, the harder cases, and that change is possible. As convener of the Justice Roundtable, I teamed up with Roach Brown, host of WPFW-FM's Crossroads radio show, to co-host the first ever National Clemency and Criminal Justice Reform Radiothon. This half-day show was broadcast on the 45th anniversary of the unceremonious declaration by then President Nixon of drug abuse as public enemy number one. Shortly after this June 18, 1971 proclamation, the media popularized the term war on drugs. We now know that this war on drugs was a stratagem for criminalizing Black people and critics of the Vietnam War, and has today resulted in the mass incarceration of over 2 million people. The purpose of our Justice Roundtable Radiothon was twofold: to spotlight and give voice to the men, women, and families who have been impacted by mass incarceration, and to examine various strategies in the criminal justice reform toolbox that could be used to provide relief, including executive clemency, legislative reform, compassionate release, judicial second look mechanisms, and reentry. For the past 45 years, the media have played a huge role in fanning the flames of the horrific war on drugs. We challenge the media and policymakers to listen to the featured speakers in the Radiothon and use the personal stories and the educational information as an important part of narrative change, with the goal of reuniting families and strengthening communities. Clemency expert Mark Osler participated throughout the day with us in the studio. Veteran WPFW anchors Askia Muhammad and Gloria Minot added this special flavor. This first ever 6-hour radio focus on clemency and criminal justice reform was chock full of change makers. Judiciary Committee ranking member Representative John Conyers called in to make remarks. DC's Congresswoman Eleanor Holmes Norton dropped by the radio station to announce her bill calling on the president to delegate clemency authority for DC prisoners to the district's mayor, as DC has no governor to play that role. Celebrities MC Hammer, Keith Sweat, Adam Rodriguez, Lamont Rucker, and Maria McDonald called in to stress the need for sentencing reform and executive clemency. Here's a picture right here. WPFW 89.3. Where am I? I'm in the middle. There's Roach right next to me. This is our wife, Mertine. This is Skia Muhammad. Mark Osler is there. Gosh, my sister. Oh my gosh. Anyway, WPFW royalty there in the house. So let's see, where are we? Okay. Calls came in from commutation recipients Norman Brown, Kimber Smith, Amy Povard, Jason Hernandez, Ramona Brandt, Shauna Berry Scott, and Sharonda Jones, who joined scores of other formerly incarcerated women and men, such as Andrea James, Weldon Angelos, Yango Sawyer, Glenn Martin, Teresa Hodge, Topeka Sam, and Phyllis Johnson, in demanding criminal justice reform. I'm sorry, the other picture here, that's Katia Smith-Stitt. Is her, I forgot to mention her, from WPFW. Alice Marie Johnson, Craig Seychal, Tyree Bell, Eric Wilson, Eon Shepard, and others called in directly from prison. Family members Ebony and Anthony Underwood, Miquel West, Tony Lewis, Deborah Kane, Erica Wilson, and Miss Clementine brought attention to their loved ones languishing behind bars. Civil rights leaders Wade Henderson Leadership Conference, Sherilyn Eiffel, NAACP Legal Defense Fund, Dorian Spence, Lawyers Committee for Civil Rights Under Law, and Sarah Totoshi, Southern Center for Human Rights, lent their voices and the power of their organizations. The voices of the Cup 50 crew, including Shaka Senghor, Matt Haney, and Jessica Jackson, were heard. Conservative and libertarian allies Mark Holden from Koch Industries, Craig DeRoche, Prison Fellowship, John Malcolm, Heritage, joined us. Oh yeah, they did, y'all. As did Utah Judge Mark Bennett. Woo, yeah, this was a bipartisan radiothon, and it took all of us together to make all of this happen. Let's see, who else we got? Attorneys Meandro Cody, Rachel Barkow, Kendall Mentor, Cynthia Roseberry, Vicki Casanova Willis, Brittany Bird, Sophia Elijah, and Damon Hewitt weighed in. Criminal justice advocates Mark Maurer, Norman Reamer, Mark Schlinder, Angela Frazier Giles, Jessalyn McCurdy, Jasmine Tyler, Todd Cox, Karen Garrison, and others lent their expertise. And faith leaders Andrea Alexander from the National Council of Churches, Kara Gotch from the Interfaith Criminal Justice Coalition joined those representing special issues to educate the public, such as Megan Murray, LGBTQ, Dara Baldwin, disability, and Maritza Perez and Jasmine Mickens, criminalization. Ron Hampton and Damon Jones made their voices heard, representing the views of progressive law enforcement. Oh, y'all, that was major. The programming reached such a high level of attention that hashtag Justice Radiothon trended on Twitter, reaching the #2 spot in top tags that day. The one bill cited over and over for immediate passage was the Sentencing Reform and Corrections Act pending in the Senate. This was legislation that I worked fervently to pass, along with advocates in the Justice Roundtable. The need for the president to grant more commutations was also a frequent focus of comments during the radiothon. Disappointingly, I was unable to interest the White House in officially calling into the Justice Radiothon that day. It was a missed opportunity. The Radiothon gave voice to men, women, and families who have been impacted by mass incarceration and all vowed to step up the pace in support of criminal justice reform. My work in support of clemency was not an amorphous quest. I had, quote, skin in the game. And in the words of Equal Justice Initiative founder Brian Stevenson, I was very proximate to the cause. In addition to generally advocating for clemency, engaging in strategic grant making and initiating programs to increase awareness among stakeholders and the public at large, I too had answered the call for lawyers to represent clients without fee in their pursuit of executive clemency. I became the pro bono clemency attorney for 2 clients and part of the pro bono advocacy team seeking a posthumous pardon for a third. However, despite my strenuous and passionate work on clemency, I was so very disappointed and frustrated that my advocacy failed to translate into success for my own clients. I'm going to stop there, get my book, Black Power, Black Lawyer, to hear the rest of it. I'll just tell you the titles of the next part. Underwood should be home by now. So, you know, this came out early in 2020. I will say he did come home, William Underwood. So I have a whole chapter on that. I'll just show you that picture. Home for Father's Day is Underwood and his children, Ebony, Anthony, Miko, and his youngest son. So that was one client who did come home. There's a whole story about that. The next one is called The Voice of Jamaica. Let's see. That was his original attorney, Chokwe Lumumba, the lawyer, the former mayor, the elder, and the client, Buju Banton, who I represented after the passing of Chokwe Lumumba, reggae award-winning, Grammy award-winning reggae recording star, pegged as one of the most important musical voices to come out of Jamaica since Bob Marley. I initiated a clemency petition on his behalf. He was not released through that process, but he was released. And then finally, a necessary posthumous pardon for none other than who? The Honorable Marcus Messiah Garden. I am hopeful that the Biden administration will issue a posthumous pardon before he goes out of office. Oh, is that next week? Oh my gosh. To the Honorable Marcus Messiah Garvey. Let me just show some more pictures here. It's a picture of some of my Justice Roundtable colleagues. Okay, my partners are crying. There's Jesselyn McCurdy sitting next to me. There's Nicole Porter from the Sentencing Project over there. There is Nicole Austin Hillary. Everybody had different positions and jobs at that time. And there is none other than Sakira Cook. all movers and shakers, all helping to make things happen. This was in the White House's bowling alley. We were treated to that treat back in the day. Yeah. So anyway, this was Nikichi checking my email one more time. It's 10:40 a.m. Eastern time on Friday, January 17th. Just checking to see if names have come out. I just President Biden has announced that he is commuting over 2,000 sentences today of drug offenders, and I'm hoping to see if Michelle West, the mother of Michelle West, actually really the only person from that White House wraparound events that we did during the Obama administration, of all the family members who were there, everybody's loved one who was there at that convening that we brought together, they are all home now. Every one of them are home now. But Michelle West still is not home. And I am so very hopeful that today's commutations includes her name. And if not today, that her name is included before the end of the Biden administration. So again, this is Nikichi Taifa. Everybody knows I work on the issue of reparations now, and many people only know me in that context. But let me tell you, I had a whole long, lengthy, phenomenal career in criminal justice reform, which we call criminal legal system reform now, that serves as a background to a lot of the momentum that we see today. So my voice is hoarse. I will be doing my whole book as an audiobook soon. It's supposed to come out 5 years ago when this book came out in early 2020. But I vowed to do that because I know nobody likes to be, though nobody wants to listen to long stuff also. But hopefully you will kind of listen to this. So you see again that things don't just drop from the sky. Love you so much. This is Nikichi Taifa signing off. If I can figure out where the I can't even see where to sign off at. Okay. Oh, here it is. Peace and blessings.